My name's Showell Blades. I'm an attorney in Rock Hill. I've been here since about 1989. I've practiced primarily bankruptcy law, have since 1986 really. I primarily represent debtors. I'll define the various parties to a bankruptcy in a second. They're in your text. But first, you might wonder, why in the world do people file bankruptcy? And, it doesn't seem like a very, nice thing to do. No one really wants to do it that comes into my office as far as I can tell. But I looked up a few statistics for you, and have been told a few statistics at some seminars I've been to recently, so I thought I'd share them with you. For example, in a year, 25% of the ARM mortgages in the country will, how they get you a variable rate mortgage fixed for 2 years, and then they start going up with prime. 25% of those that are out there, their 2 years is up next year. So I've had people coming into my office lately, a lot more this year, it's happening with more and more frequency, who got into houses. They're not financially savvy. They got into houses. You see these signs. There's one on Main Street heading out towards the family court that used to have a sign in front of the subdivision that said, $100 down, gets you a house, basically. And I'm sure they got some really nice lending packages for these people. And basically, some of those kinds of people are coming into my office where they started out with a $700 a month payment, and 2 years later, they're at $1,000, $1,100, and climbing until they reach the cap of what interest rate they can be charged. And so you've got a lot of people out there like that. As far as hospital debt goes, excuse me?
Would you say foreclosures are on the rise?
Yeah. I mean, you can monitor that yourself if you look at the Master and if you look at the YorkCounty.gov website, Master and Equities website. Within that government website, they put current auctions, and the first Monday of every month in York, they're selling houses, and basically, I monitor it every month. And yesterday, they sold 45 houses if the sales went through. Last month, it was about 70-something. It fluctuates between 50 and 140 houses for sale every month, or they're at least on the website, which means they've gone past the hearing stage and they're almost to be sold. So yes, foreclosures are on the rise, at least what I see. And we're supposedly in, one of the most financially stable, wealthy counties in the state, perhaps. And certainly our region, if you read on, things you get on the internet, on the websites, talking about the real estate bubble about to burst, most articles talk about this area, the Charlotte metro area, being pretty stable. And so I'm sure it's worse in other areas. But as far as hospital debt, I read something Friday that said each year the United States' 6,000 hospitals generate $129 billion in bad debt. That was on the American Bankruptcy Institute's website. And then it also indicated that 2.49 million jobless, the rate of joblessness with people that they measure it by checking the people who have filed for unemployment and then they file again, consecutively. That they had 2.49 million jobless claims as of August 26th in the country. And if you think about it, those are the people whose unemployment hadn't run out, who aren't disabled and trying to get disability, and therefore they're not getting unemployment, or they're just self-employed and their business has failed, and so they don't get unemployment either. So that number is really probably a low measure of how the employment rate is in the country and how people are doing. Professor Elizabeth Warren of Harvard Law School did a study about, it was published a year or two ago, and it was, I think the data was, say, 5 years old, and it basically clearly showed that the three main reasons people file bankruptcy are divorce, which I think the divorce rate in this country is about 50%, unemployment, and then personal or family medical problems. And you know, I knew that just from practicing in this area of the law for the last 20 years, and most debtors attorneys I talk to, we all kind of feel those would be the big three reasons. And another reason that's developed over the years is just how easy it is to get unsecured debt, and specifically credit cards. I mean, last year I was at a seminar in Mecklenburg County on bankruptcy law a couple of Fridays ago, and this professor from Wake Forest was there citing, Wake Forest Law School was citing statistics, and one of the things he said was that, and I had read this before, was that last year the credit card industry mailed out $30 billion of pre-approved credit cards. I mean, I don't know how many of y'all get those in the mail, but my daughter kept getting them before she turned 18 and went off to college this year. So I think the unsecured debt is a problem. Not that people are out there charging vacations, but you know, if you're unemployed and or your business is going down the tubes and you're trying to save the American dream and you're an optimist, you might be tempted to get that $5,000 this letter tells you to take and make things work for another month till it gets better, because of course it's going to get better. And then it doesn't. And that's how you end up when interest rates, when you miss a payment, they go to 33%. That's how you end up with $50,000 in unsecured debt before you knew it. So bankruptcy is a way for people to deal with that. We don't have the Wild West where you can go just leave the state and move away to hide from your creditors. There aren't many places to hide in this country from debt collectors. They'll call you and threaten you at all hours of the day and night, and the debt collection laws they're there, but you have to prove who's calling you on the phone. You have to prove that they've actually called you. You don't have their name usually, and for each violation you can get $1,000. And then most of the debt collection laws are that way. So in that context, that's why bankruptcy is in the press so much, and that's why what I do for a living is file bankruptcy for people and advise people. And I don't advise everybody I talk to file bankruptcy. That may not be their best option. So generally, what is well, and the way I'm going to do this, I'm going through your materials. I'm not going to read it to you because y'all can read, but the materials were written by David Duncan. He is a lawyer used to live in Rock Hill, a great guy. Used to work partners with the guy that trained me, and David is now Judge Duncan, so I think the materials are probably pretty good. I thought they were after I reviewed them. But I'm going to go through them and sort of generalize what each section is about. And if y'all have any questions, feel free to raise your hand, and then I'll try to answer them, unless we start getting too bogged down with questions. But if you have a question and you raise your hand, probably other people do too, and maybe I can clarify that for you. But first of all, bankruptcy, what bankruptcy law is it's the law that is set out in Title 11 of the United States Code. And I say United States because, bankruptcy law is the same in every state in the country. It's federal law. You've had a class on state courts already. I think that was maybe your first one. And you know that we've got all these different courts in South Carolina, and they're governed by the Supreme Court and funded by state taxes and so forth. Well, the bankruptcy court is a court that sits mainly in Columbia, South Carolina, and it's governed by the United States law concerning bankruptcy. And basically all the rules that govern it are federal rules, and the federal rules of civil procedure, or how you run your court, are controlled, not the South Carolina rules of civil procedure. And basically, we have 3 bankruptcy courts in South Carolina. There's one in Charleston, one in Columbia, and one in Spartanburg. And but everything is filed at the clerk's office in Columbia. And when I say filed, it's not like you drive it there. You used to till recently, but now everything is filed on the internet. You actually have to have a court order to file a piece of paper in court, and they charge the lawyer's credit card when the case is filed for the filing fee, and that's just how business is conducted. It's over the internet with emails and so forth. But basically, the whole point of the bankruptcy system is to give debtors, the people who owe money, balance their right to maybe have a fresh start when things have just gotten so bad and there are no other options. They can file a bankruptcy, and the system is set up to see about giving them a fresh start versus the creditor's rights, because you can't have people just filing. It doesn't take much to file a piece of paper at the bankruptcy court or an email petition, stop some legal action. And if that was all there was to it, I mean, you would have a lot more problems with the bankruptcy system. But as it is, you file your case, and if you don't do everything just right, so that everybody knows what's going on in your case financially, so that the creditors can review the file to make sure you did everything the right way, then basically the case is thrown out. There are a lot of pro se filers out there now, people who don't have lawyers, that you can go buy a bankruptcy package at Office Depot and it'll tell you how to do it. It's not always right. In fact, it leaves out a lot. But people file those regularly to stop foreclosure sales and take action to protect themselves. And unless you really know what you're doing, a lot of times it doesn't work out. But some pro se filers do better than some lawyers out there. So it's not saying you can't do it yourself. You have that right. But basically, the bankruptcy code is there to balance the rights of creditors and debtors. And the people who are the parties to a bankruptcy, you've got the debtors. Well, if you go out and you borrow money, you're a debtor. And if you file bankruptcy, the person that files the bankruptcy is also called the debtor. And a creditor, it seems common sense, but if somebody owes you money, you're a creditor. But in the bankruptcy system, when somebody files bankruptcy and owes you money, you are a creditor. And when somebody files bankruptcy, in most types of bankruptcy, the court appoints somebody called a trustee who actually reviews the file, investigates everything that's attached to the petition when it's filed, and to make sure it's complete, correct, that it makes sense, and that you can understand basically what this person's situation is the day they file bankruptcy financially, maybe how they got there, what information, you have to give a lot of information on historical data of the last few years, any transfers of assets you've made, things like that. And you have to also give some projections as to what changes you expect in your income and your expenses for the next year. And everything you sign is under penalty of perjury, so you can go to prison. I've ever had one client go to prison, but that was been a while back, and he never did admit that he was guilty, and I believed him all the way, but the jury didn't. But the bottom line is you basically have to disclose a lot of financial information. The trustee's job is to review everything, make sure it's complete and correct. He can ask you any questions he wants at a hearing that happens 30 days after you file bankruptcy. And they can ask you to produce about any information concerning your finances or transfers of assets or anything like that that they want to ask you. So that's the trustee's job. And then another term that you may hear, you don't hear it as much, but is called debtor in possession. And that is a Chapter 11 term. That's a type of bankruptcy that U.S. Air did. It's when a corporation wants to reorganize, or an individual who can't do an easier, cheaper kind of reorganization needs to reorganize, they'll do a Chapter 11. And there isn't a trustee in a Chapter 11. Unless the debtor screws up and violates the rules or doesn't give a complete disclosure like they're supposed to, the debtor can run the show in Chapter 11, and I'll explain that more later. But so the debtor who is taking care of his Chapter 11 without a trustee is called the debtor in possession. And finally, you've got the U.S. trustee. Excuse me. The U.S. trustee is someone who works for the Department of Justice. There's actually an entity called the United States Trustee Program. It's under the auspices of the Department of Justice, and they have an office in Columbia that basically oversees all the bankruptcies filed in the state. And they can appear in court if they don't like your files and don't think they're complete. They'll show up at your hearing and they'll ask you more questions than maybe the trustee, and they can file a motion to dismiss your case if they think you're not doing something proper. They also basically audit all the trustees' files to make sure they're not absconding with funds or something like that. That is basically their primary function. Is sort of an overseer position, but they do appear in cases and take actions when they feel they're warranted because nobody else is doing it. The final party, and it's not really a party to the action, but is the judge, the bankruptcy judge. We have 3 bankruptcy judges in South Carolina. 2 of them live in Columbia, 1 of them lives in Spartanburg, but they all 3 appear in Spartanburg, Charleston, and Columbia, and there's a schedule that goes about 6 months out in advance, and there's random assignment of cases for the most part, so it's not like you shop and can pick your favorite judge or anything. But the judge decides disputes. That is the judge's primary function. The judge doesn't appear at this first hearing, the meeting of creditors, which I'll explain in more detail in a second. But if the trustee has an argument over some fact or something that's happened with the debtor, or the U.S. trustee feels that some rule has been broken, then whoever has a problem with whatever action has been taken or hasn't been taken files a motion or a lawsuit in the bankruptcy court and asks the judge to decide it. And so the judges have hearings pretty much 5 days a week in Columbia. I don't know their schedule in Charleston because I don't appear in Charleston very much. But in Spartanburg, they appear less frequently. But Judge Burris now is living in Spartanburg, and she holds court there fairly regularly. But that is the function of a bankruptcy judge, and they're appointed, I think, for 12-year terms that are renewed. We've had 2 judges, and then 1 retired last year when the law changed, which was pretty smooth timing on his part. And then we filled 2 more positions with his, to take his place and to fill a gap that's been needed really for 6 to 10 years. Another few terms that you need to be aware of are property of the estate. I don't know that you hear that in everyday conversation, but in the bankruptcy world, that's an important term. What it is, when somebody files bankruptcy, an estate's created. You know how when somebody dies, all their assets in the world are now in an estate at the probate court, and that is, that property has to be administered by the probate judge, and creditors have claims against them and so forth. Well, when somebody files bankruptcy, they have all their assets now become property of the bankruptcy estate. And depending on which type of bankruptcy you do, things can happen to that property. It may be used to be sold off to pay your creditors if you do a Chapter 7 and have valuable assets. You may not lose your assets in a Chapter 13 or a Chapter 11, which I haven't explained to you yet, but I will in a second, but how much the property of the estate is worth in those kind of reorganization cases determines how much you have to pay your creditors. Just a real simple example is if you've got $100,000 in credit card debt and bank loans and doctor bills and business loans, but if you sold everything you had and only could get $20,000, then if you were going to do a reorganization, you would have to pay at least $20,000 to your creditors because they couldn't get any more by taking everything themselves and selling it. So that's why the concept of property of the estate is relevant. Excuse me. Another concept, which is really the big thing you're looking for when you file a bankruptcy initially, is the automatic stay. And it's just a legal concept that basically, the two words that are in the phrase perfectly describe what it is. It's automatic. When you file bankruptcy, it's automatic that there is the stay. And stay, think of what you do to a dog, is stay. I mean, it stops or stays all creditor activity. It's not permanent. It basically, if a creditor feels that you have done something wrong after the bankruptcy is filed, the creditor can go back to the judge and ask the judge to lift the stay as to your collateral. If somebody files bankruptcy and they've got a car that has a loan on it, they're supposed to keep making their car payments. It's not like you can file bankruptcy and get your house for free and your car for free. You still got to pay people who have liens on your assets. And so if somebody files a bankruptcy and isn't paying for their car or isn't keeping it insured, or maybe they have a house and they're not paying their taxes, then the bank, if it wants to, can pay a bankruptcy lawyer on the creditor's side. I don't know what they pay them, but they charge the debtors about $750 in costs when they do that. And they basically ask the judge for permission to let them take the house or the car or whatever. And if they can't work out a settlement, the judge will give them the right to do that. So the stay can be lifted. And in other situations, there is no automatic stay. And there's a list in your materials that it's not complete, but it pretty well lists a lot of the things that, if you file a bankruptcy, you can't stop your ex-husband from going for child support. You can't stop criminal proceedings. You can't file bankruptcy and keep them from sentencing you for your burglary conviction the next day. There are just certain things that the system will not allow, and so the stay it can be lifted. It's not always there, and in some situations it can expire by termination under the statute. There's part of these materials talk about the new bankruptcy law as if it hadn't quite happened yet, because they were written last year, and the bankruptcy law changed. Probably the most has changed since 1978. It took effect October 16th, 2005, and there were a bunch of changes, and basic of them said that if somebody has filed a Chapter 13 bankruptcy, and that's a repayment plan, and they have done that, and their case is thrown out or dismissed for non-payment, then basically they can't file another bankruptcy within the same year, or else the stay expires in 30 days. And the reason that is a lot of people, houses will be in foreclosure. They'll file a Chapter 13 to save their house, which is the main reason that people file Chapter 13s, I would imagine. And their case will be thrown out because they lose their job or they just can't make it. And so the bank, takes its actions eventually and will put the house back up for foreclosure sale. And a lot of people will file bankruptcy again and stop the sale. And in some cases, that's perfectly legitimate. If you're in a Chapter 13, you've been in it for 2 years making your payments, and all of a sudden you get in a wreck and you can't work for 3 months. You can't make your mortgage payments or your bankruptcy payments, and then your house is up for sale again when your bankruptcy's thrown out. And in those cases, it's pretty much a legitimate tool to use a Chapter 13 again to stop the sale and start the process over again, trying to pay your debts back. But there are a lot of people, not really that much in South Carolina. We're a pretty conservative state as far as filings go, but California is a big offender, at least what you read about in the journals. But there are mills that will advertise that they do bankruptcies for people, and all they do, you pay them $100 or something, and they'll give you the forms, tell you where to file them, and people were just walking them over to the courthouse and filing them, and it was stopping foreclosures. And you were having some people who'd filed bankruptcy like 10 times, which that would never happen here. I mean, it just doesn't. Our courts just nail people for doing stuff remotely approaching that. But basically with this new provision, after 30 days on your second filing within the same year, there is no stay, so the bank can foreclose. It doesn't have to get permission from the bankruptcy court. So all these people who are doing these repetitive filings just to keep saving their house when they really can't make it and shouldn't be filing another case, they aren't able to do that anymore. Now, another concept is a proof of claim. When you file bankruptcy, yeah.
If a person files bankruptcy because of a pending foreclosure, they can't make the payment.
They can't make the payment on the mortgage?
Right.
Okay.
Can they themselves sell the house during that time period?
Did everybody hear the question? Okay. You can sell your house. You have the right to sell your house and be in your house until the day your house is sold at foreclosure sale. And that's there is some misconception out there, because people, banks, collection agents, and others will tell you that you have to get out of your house, or there's just a lot of people spread mistaken information frequently. But no, if you were served with a foreclosure action, and I'm kind of veering off here, but basically when you're foreclosed upon, what happens is they have to send you what's called a right to cure letter. They serve you, they mail that to you. I can't remember whether it's 20 days or 30 days, but they have to give you a certain period of time, it's 20 or 30 days, to bring all the money that you're behind current. And that means all of it in what time. If you do that, they have to drop any activity heading towards foreclosure. They only have to do that for you one time in the whole life of the loan, whether it's a 30-year loan or whatever. But once they've done that, if you don't bring that money in, then they accelerate the loan, which means they call the entire balance of the loan. And then the next step is they serve you with a foreclosure action, and you either use a process server, sheriff's deputy, or they mail it to you certified mail, return receipt requested, and you sign for it. Or someone in your house who's an adult can sign for it. That's a problem. Sometimes people are like, I didn't get that. Well, your 18-year-old son did and left it under the sofa. Well, you've been served. And so you have 30 days from the day that you get that to respond to that lawsuit, and if you don't, the bank automatically wins. Now, that's basically what happens most of the time, because people don't respond to those things, even though it says it in a bunch of gobbledygook on the first page. But the next thing that happens after the bank wins is it's still in the foreclosure setting, has to have a hearing. And so they give you usually around 30 days notice of that and a letter, and they set the hearing over in York in front of Judge Kimball. Those things are scripted. I mean, the bank's lawyers show up with their transcript already typed, because it's the same thing every time. There's never much opposition. And the judge, not that there's corruption, it's just, they prove that you owe the money, that you're behind, and you haven't brought it current, and that they've done everything proper procedurally, and that's about all there is to it, and most of the time. And then the bank wins, and the judge orders a sale. Then they publish notice of the sale in the paper once a week for 3 weeks in a row, and they sell the house. And in our county, we have a set sale day. It's the first Monday of every month. Unless it's a holiday, they go to Tuesday. But so you can see that's like either 81 or 117 days if the bank goes right on the ball after every step they move to the next level. And they usually don't because they're busy. They go as fast as they can. So anytime after you're served with that foreclosure action, you can bring the loan current, or you can sell your house and pay off the debt, or you can file a Chapter 13 bankruptcy. And I mean, I filed 4 bankruptcies on Sunday, and because we can file things 24 hours a day, 7 days a week on the internet, and houses weren't sold yesterday. And I do that pretty much all the time. And the reason I did that on Sunday was it was the first of the month. That way it gives my clients 30 days to not have to make a mortgage payment or a bankruptcy court payment till November. So that way they can actually start out and they might make it instead of not, being behind. But any other questions at this point? Was that a hand or scratching your head? Another issue is proofs of claim. When somebody files a bankruptcy, there are several kinds, and I'll go into them in just a few minutes, but you're either going to wipe out your debts or discharge them, or you're going to reorganize your debts and pay them a way that's different than what you and the bank agreed. Those are your 2 basic goals in any bankruptcy. If you do the type of bankruptcy that's called Chapter 7, then the trustee's job, one of the trustee's jobs, is to see if you have anything that he can sell to make money to pay the creditors. And basically, if he does sell your assets, then he's going to send a notice to all the creditors and tell them to file proof of claim, which is proving that you really do owe them money rather than just you're saying it. So, only people who really are owed money get the money from these bankruptcies. If you do a reorganization and you want to get money that way, then you have to file a proof of claim in that bankruptcy so that the trustee can look at it and see if you really are owed money and know how much to pay you. Another concept is exemptions. What an exemption is, it's a certain dollar amount of certain types of property that no one can take from you. No creditors can take from you. Now, that doesn't mean that people who have the lien on your car that are financing your car payments can't take that if you don't pay it. And it doesn't mean that, they can't foreclose on your house if you don't pay your mortgage. But if a creditor is actively pursuing you to get its money, just a simple example, you owe your Visa card $5,000. You don't pay them. The next step, if they are going to, is they sue you and they get a judgment. Well, the way you collect a judgment is you try to take the assets people have from them to help pay off your judgment. You can't take people's stuff if you're a creditor unless you've got a judgment or a mortgage or something like that. But if you get this judgment, the sheriff's going to take it to you and they'll ask the sheriff to execute the judgment. And that means take your property. Well, where the exemptions come into play is this is the property that the sheriff can't take from you in that situation. And that's not a bankruptcy law issue. That's a South Carolina, Virginia, North Carolina, Florida, California. It's a state court given right. And it's really screwed up because each state has different exemptions. When you file a bankruptcy, you have to claim the exemptions that used to be in your state. When the bankruptcy law changed, it really muddied that water, and now you have to look back where people have lived the last 2 years, and if you hadn't lived anywhere 2 years, you go like the majority of 180 days before that. It's chaos. Right now I got 3 clients, I'm trying to figure out what the exemptions of Pennsylvania and Maryland and some other state are, and I mean, I'm not licensed in those states, but now I've got to figure out what their law is regarding exemptions. And the bottom line is, when you file a bankruptcy and claim your exemptions, you're claiming them to keep the trustee from taking your assets. And so they're an important concept. Right now, the big problem we've got in South Carolina is South Carolina has had really low exemptions relative to most other states for as long as I've been practicing. The current exemption law was set in place about 1981, and it hasn't changed. And that's when what the legislature said you should have protection against being taken back in 81, and it hasn't been changed for the cost of living. Back then they said you could protect $2,500 worth of ordinary household goods, $1,200 worth of equity in your car, $5,000 worth of equity in your house, $750 worth of equity in tools of trade. Depending on how much life insurance you have, most of that cash value is protected. And then you can also protect like an ERISA qualified retirement plan, like a 401k or something. And that's basically it, I think. And the cost of living and the cost of all of those assets has gone up so dramatically since then that maybe those numbers should be higher. Well, May 25th, they raised the exemption for houses, for residences, to $50,000 a person instead of $5,000 a person. So, if you've got a house, theoretically, you and your wife could protect $100,000 worth of equity in your house from your creditors, which is, if you're a debtor or a debtor's attorney, that's like an incredible bonus. And it's not, Florida's unlimited. That's why Florida has, one of the reasons it has a high level of entrepreneurs and older people moving there is because you can't lose your house. Your house is protected from everybody. And I mean, where it's abused is, I can't remember the commissioner's name, but one of the commissioners of baseball got in a lot of trouble, and he sold his house and bought he sold all his assets and bought like a $53 million house in Florida and was able to protect it under the Florida law. And the exemption when the bankruptcy law changed last year, there was a change in it to put a cap on that to prevent those kind of abuses that kind of make everybody scratch their head and go, wow, that's really not a good thing. But
now you're saying that the federal law in that case overruled Florida, or Florida?
Well, it's basically the way the exemption statute is drafted. In the bankruptcy code, there is Section 522 is the exemption statute. It's what says all these things are protected. And it's much more generous than South Carolina's. Well, there's a clause in there that says all the states are free to opt out of the federal exemptions. They say, well, we don't want to use those in our state. And South Carolina's opted out. North Carolina has. Most states have. And so when the bankruptcy law changed, they added a provision in the exemption statute. I can't quote it to you right off the top of my head, but it basically said you can't claim more than $150,000 worth of equity in your house no matter what, and it put restrictions on the amount of time you had to have lived in that state before you filed bankruptcy and claimed this humongous household exemption. And so that's how they restricted that. So in a way, the federal did kind of trump the state's intent. Anything else on exemptions?
Yes, in practice, how does that work? In other words, if you had, say, $100,000 exemption,
Yeah.
your house is worth $150,000,
Right.
and the bank wants to take it, in practice, what happens?
Now, is there a mortgage on that house you're describing?
Yes.
Okay. The bank, what happens if the bank is executing on its judgment? It basically ask the sheriff to sell it. And then the sheriff has to have a sale. And the sheriff sells the property. And then he has to pay off, whoever buys the property at this auction is how it's done, has to bid enough to pay off the mortgage, give the debtor his or her exemption, give any other people who own that property with the debtor their share of the money, not subject to any claims of creditors. I mean, simple example, $100,000 house, $50,000 mortgage. Right now, and I'll explain why I'm saying this in a second, we really have a $5,000 exemption in South Carolina still, because the $50,000 has been challenged by 3 bankruptcy trustees. There hasn't been a hearing on it yet, and so nobody's claiming the $50,000 because you don't want your client to lose. You don't want your clients that own this house to lose $100,000 and then you get sued for malpractice because you told them they could save their $100,000. So right now, anybody that's got a lot of equity in a house, you're crazy if you tell them to file a bankruptcy right now. But to give you a simple example, if you have a $100,000 house with an $80,000 mortgage, you have $20,000 worth of equity. If the house is owned by a husband and wife, then each party has $10,000 worth of equity. If there's a judgment against the husband, he has a $5,000 exemption. So he only has $5,000 of exposure. Because you take y'all can do the math. You take the $100,000 house, knock off the mortgage. If the sheriff sells it, he's got to give the wife her half of the equity from the sale. And got to give the husband $5,000. The rest goes to that creditor. If it's enough to pay off the creditor's debt, then husband gets the rest. But the sheriff has his costs and so forth. And in a bankruptcy situation, if you file a Chapter 7 bankruptcy, the trustee's wanting to sell your house if in that situation. But if you have that equity, he knows he's got to list your house. It may take 6 months. He's got to pay a realtor. He's got to deal with all the related issues of having to secure the house. You're living in it. Is he going to evict you? What is he going to do? So in actuality, if the equity is not that great, the bankruptcy trustee will make the debtor pay him money within 6 months for the equity that the trustee would make theoretically by selling the house himself. So that's a way to keep your house, file a Chapter 7, and save your equity, but you still are paying the money to the creditors. It's just you're paying it to the bankruptcy trustee. But that's about it for exemptions, unless anybody has any questions.
One question.
Mm-hmm.
In a bankruptcy case, where a man and woman are living in the home,
Right.
$100,000 home, and there's no mortgage, they own the home,
Right.
can the bankruptcy court foreclose on the house?
Well, the foreclosure is what a mortgage holder does. Only somebody who has a mortgage on the house can foreclose on it and basically take the house. What a bankruptcy trustee does is sell assets that aren't exempt. You've got these assets that nobody can take from you, your creditors can't take from you. The bankruptcy trustee can't take them either. But he can take your house. He just can't take the first $5,000 worth of your equity in the house. There is a $50,000 exemption, but it's been objected to by these 3 trustees because the trustees found an 1898 South Carolina Supreme Court case that says it gets complicated. But this will all be dealt with probably in the next 6 months. Before now, we're kind of in limbo.
How long has it been in challenge?
Since July. What happened is 3 people filed bankruptcy relying on the new law, and one of the trustees' jobs in the Chapter 7, if he thinks your exemptions are not right, he'll object to them. And in 3 different cases, 3 different trustees objected to these people, these lawyers and clients claiming the $50,000 exemption, which the South Carolina legislature gave to them. But what they did was they objected because there's an 1898 case in the South Carolina Supreme Court that says that if you're going to claim an exemption, you have to use the exemption that was in place at the time you borrowed the money against the particular creditor trying to go after you. And so,
Bankruptcy in 1899?
pardon me?
We had bankruptcy laws in
The first Bankruptcy Act was 1898. We had the bankruptcy is authorized by the U.S. Constitution. It says that Congress shall make uniform bankruptcy laws. They made laws periodically over the years. I couldn't tell you exactly when, but it was in response to like some depression or crisis or something. They were short-lived. And then in 1898, they passed the Bankruptcy Act. And you'd hear all these lawyers who are older than I am but still around talking about practicing under the Act. And that was the 1898 Act, which wasn't revised much till 1978. And then we got the U.S. Bankruptcy Code, and now people are practicing under the Code. And that's been modified significantly last year. But, yeah, we've had bankruptcy a while. Another concept is reaffirmation agreements. That's where when somebody files a bankruptcy, under, say, Chapter 7, where their goal is to wipe out their debts, you can sign an agreement with your creditors promising to repay them after the bankruptcy is over. And the downside of that is if something happens, you're in bankruptcy because you've suffered some setbacks, and if you keep suffering those setbacks and you've signed these reaffirmation agreements, then you basically owe the money that you filed bankruptcy to get rid of. So you don't want to reaffirm any debts unless you know you can really handle them. And the new law made some changes in reaffirmation agreements, but they're just, I can go over them, but I don't think y'all really want to hear it. It's a little complicated. Basically that all you really need to know is that if you want to keep paying a debt after you file bankruptcy, you can sign a reaffirmation agreement and you will owe the money when the bankruptcy is over. And one thing I'll mention here doesn't have anything to do with reaffirmation agreements, but if you want to, I get questions a lot from people saying, I filed bankruptcy, but I want to pay my dad or I want to pay Founders Federal Credit Union because they're good to me, Well, you can pay any creditor that you want to pay when you file bankruptcy. You could pay all your creditors back after you file bankruptcy. It's just this keeps them from coming after you because you aren't able to pay them all at the time they're all coming after you. So it's kind of a barrier. But the next thing that I'll touch on is I've mentioned a hearing that happens after you file bankruptcy. Well, what that's called is the meeting of creditors. And what they call it the meeting of creditors, but it's kind of an oddly named hearing because usually no creditors show up. What happens when you file a bankruptcy, we file this paperwork with the court. It's about 50 pages long. We have to file it over the internet, but we scan and attach your pay stubs for the last 6 months for everybody in the household. We basically scan, make a list of all the assets in the house and what they'd sell for, say, at a garage sale. Unless there's something like an antique or something special, we get that appraised. We attach the tax statements from the county for houses, any vehicles, boats, etc. We attach any appraisals from on any real estate that you've gotten that you have a copy of. We check all 3 credit bureaus and get everybody listed on those. And basically we give a pretty complete picture of their finances, of the people's finances, when we file the case. And then after we file, we've got to mail the trustee the last 3 years tax returns, 3 months bank statements, and a bunch of other things. And all of this goes to the trustee. And when you file your case, the court sends me an email 3 minutes after we file it, giving me a case number, saying you're in bankruptcy. And then, there's also a notice that goes out to all the creditors and anybody listed on the matrix, the list of creditors. And it goes out telling all the creditors that you have filed bankruptcy, not to contact you, to call the debtor's attorney, gives them my name, phone number, address. tells them there's a meeting of creditors or a hearing set about 30 days later, and then they can come if they want. And basically, you know, I have to be at the hearing, my clients are at the hearing, and the trustee is at the hearing. And it's a pretty low-key situation. Everybody's kind of upset, but the trustees don't grill people unless they're just disrespectful or have done a sloppy job, or their lawyer's a repeated idiot or something like that, so their paperwork's never right, and that happens sometimes. But basically, you know, we go to this hearing. They try to do 8 hearings every half an hour, and that seems like a lot. And that was one of the things that one of the Congressman Grassley, that was one of the big proponents of the bankruptcy law changing, was he just thought that was terrible and there wasn't enough attention being paid to the system and all that. And he knew this because he'd sent somebody from his office over to look at bankruptcy hearings, and that person knew nothing about how they worked. But basically, you know, the trustee gets your file over the internet within 24 hours of the filing. They get all this other information. They have a staff person assigned to your file. They review the file. They call me or email me if they have questions about something. They send letters to clients telling them to produce all these documents in their office before the hearing. So there's a pretty significant investigation of every case before the hearing. The U.S. Trustee's office audits every file. This file, they look at the budgets, they check the data. Starting October the 16th, as a birthday present for all of us who've survived the new law for a year, the U.S. Justice Department will start randomly auditing every 1 out of 250 cases that's filed in the country. So basically, these files are reviewed with a fine-tooth comb to make sure people are doing things the right way and they're not hiding assets and so forth. And so when we go to this hearing, the trustees are just doing their job and getting the person to go under oath and swear that they reviewed the paperwork before it was filed and everything's true under penalty of perjury, and there have been no changes since the filing date and so forth. And really the reason they do that in most cases, because there aren't any assets in a Chapter 7 to be taken in most cases. They do that so if they prosecute you for lying, they can get you for perjury as well as signing false statements. They can get you for false testimony too. And sometimes you look people in the eye and you know, sometimes people break down if they're really not doing something right. You know, you see some lawyers looking at their clients like that in these things, but most of the time it's an administrative hearing where they're just going through the motions and finding out information. It's there for the creditors to ask questions if they want, but frankly, most of them don't ever send anybody to the hearing. Let's say I've been practicing here since '89, and I've probably filed, say, 3,000 bankruptcies. And every one of those cases has creditors. And out of all those cases, you know, each of those cases, I mean, I probably talk to 10 times the people that ever hire me, because, you know, I don't charge for my appointments. I have, you know, people coming in complaining about threats they've gotten on the phone or lawsuits. They bring their lawsuits in just not knowing what it is. And so, you know, I'll explain what their options are, and, you know, I'll never see them again. And I do a lot of that. And basically, I've never had anybody come in where the sheriff actually took their stuff, because most people don't have anything. The sheriff deputies, I mean, they've been through their training. They're police officers, basically. They're enforcing the law, and they're there. But, you know, creditors have the ability, if they choose, to go and get assets themselves. And I think maybe the law enforcement doesn't like getting involved in that. I don't know that for sure, but I mean, creditors can aggressively pursue their rights if they choose to. And just having the sheriff run out there and try to take somebody's musty sofa that the dog's been sleeping on and sell it at an auction, it's not a real good use of county resources. And so I assume that might have some relationship to the reason why I've never seen them do that. But I mean, it can happen. I mean, if you have a really big house on the lake full of antiques, the sheriff's ultimately going to be forced to take the stuff. If the sheriff won't do it, what you usually see is the sheriff is sent the execution papers, he serves them, and I think it says you have 5 days to pay this judgment off or we're coming back. And, then if they come back and you haven't paid it and the sheriff, you say, well, I don't have anything, look around. And the sheriff sends the execution papers back to the creditor's attorney and returns it nulla, N-U-L-L-A, bona, B-O-N-A. I don't know, it might be 2 N's, but I don't remember what that says in Latin, but it basically says they don't have anything, and I'm not going to get it for you, and that's what happens. And then if the creditor, I'm kind of veering off here again into collections, but if the creditor really thinks there's something there, they can bring what are called supplemental proceedings. They file papers at the Master in Equities office. They can force the debtor who they got a judgment against to show up and be sworn, and if they don't show up there in contempt of court, they can be put in jail. They have to bring all these records to the hearing, tax returns, whatever you want. You tell them to bring it, they have to bring it, and you can sit there with the creditor's attorney and they'll go over every single thing while you're under oath, and it'll all be on record. And I mean, I've done those before, and they're usually pretty boring and not much is discovered, but they just discover the people really didn't have anything. And but that's how it happens. And then if you find something, you get the master in equity to order the sale.
But
Yeah.
would it be true to say that if a person gets behind paying their debts,
Yeah.
and they have no income, and they can't pay anything on their debts, and they file for bankruptcy, in essence, weren't they adding another debt?
Not really, because what happens, and I haven't really explained this yet, but I'm getting ready to when I go over the types of bankruptcy. The end product of any successful bankruptcy that is you get an order of discharge where the judge signs an order saying that you've completed your case and that all your debts are discharged or wiped out, which means they can't try to collect them from you again. You don't owe any money.
And you don't owe the bankruptcy court anything either.
You don't. The bankruptcy court's not there to, they aren't financing your bankruptcy, or they're not a creditor. Bankruptcy court's not a creditor.
The state is the one that funds and pays bankruptcy courts and their staff.
No, the federal government funds the bankruptcy system, but it's also funded by the fees. When you file a bankruptcy, when I moved here in '89, I can't remember the filing fee, it was about $60. It was about $60 to do a Chapter 7. The filing fee for the court is now $299. And there's a bill that passed the House last week, and there's a bill pending in the Senate to raise it by 40 more. So it'll be $339 filing fee to file bankruptcy.
So you're in debt, you have no income, can't pay anything, you can't
Right.
pay anything on your debts, and then you go to file bankruptcy, and they say, well, you owe us $299.
Well, no, you don't file the bankruptcy until you pay them your $299. When I file bankruptcy for people, they charge my credit card. It's like I get if I file 10 bankruptcies, I'll get $2,999 charged on my credit card like that.
Okay, I see now, I understand.
And I collect that from my clients and pay my credit card with it.
Thank you.
Is the trustee an attorney?
They don't have to be, but they usually are. When I moved here, we had, well, in South Carolina, we have a panel of trustees. There's a team, I guess, of people who will be assigned cases when somebody files bankruptcy. And they're experienced. They have to go through all this screening through the Justice Department, and it's almost like being confirmed for the Senate or something. But basically, We had one guy, I can't remember what he did for a living before he was a trustee. He might have been an accountant or something, but he was in Greenville. And he retired 10 years ago, maybe 15 years ago, but now everybody in the state that's a trustee is a lawyer. In Charlotte, I also practice in Charlotte, there's one trustee I know of who is not a lawyer, but he's been a trustee for quite a while.
How is the trustee paid? By which side?
The trustee is paid from the bankruptcy system. Well, if you're a Chapter 7 trustee, which I'll explain Chapter 7 in a second, but when you're a Chapter 7 trustee, you are paid $60 a case. And you do a lot more work than $60 worth of work for a case to investigate it and all that. But the kicker is, if you discover assets that you are able to liquidate to pay the creditors, you get a commission. And it's a sliding scale that starts out up here and goes down here pretty fast. But if you get a big case, the guy that I used to work for, who's of counsel with me, Ryan Hovis, he got the Air South bankruptcy when it was filed. He had all these people, employees coming wanting their money. They thought he had their paychecks or something, and they didn't really know how it worked. But he got a commission off of that. And it can be substantial if you have a big case, but usually there aren't very many asset cases, much less big asset cases. If you're a Chapter 13 trustee, you get office staff to help keep up with all the money that you're collecting from debtors, I'll explain 13 in a second. 13 is a payment plan. You pay money to the trustee, he pays your creditors based on the claims that they file. And he collects a commission based on the money that he receives. I don't remember what it is off the top of my head, but it's a percentage of the money that's paid in, and he also gets some expenses to help get the staff to run his overhead. I can't remember what his salary is capped at, but it is capped. It's not like he could make a ton of money, like $300,000 or something like that. But that's how they're paid. They're paid by the money they generate mainly, and some is funded through the U.S. government. Because they're U.S. government appointed people overseeing the U.S. government's system, basically. Any other questions? Okay. What bankruptcy is just the bankruptcy law. Well, there are different kinds of bankruptcies, and each one is called by its chapter. And some I'm not really going to focus on much, but Chapter 7 and Chapter 13, because that's what I primarily do. There is a type of bankruptcy called Chapter 11, and I file those as well, but no one files that many of those. Sometimes South Carolina has gone a year without filing any Chapter 11s or anybody filing any in the state. And then there's Chapter 12 and Chapter 9. Chapter 9, I know they're filed, but I don't know when the last one was filed in the country. It's a municipal filing. If Rock Hill wanted to file bankruptcy, I know politicians are always saying we're bankrupt, but if you really are, you file a Chapter 9. I don't know that one's ever been filed in South Carolina. I just don't know. Chapter 12 is a reorganization of a specifically defined group called family farmers and family fishermen. They're set based on how much debt you have. If you're a family farmer, and that's specifically defined in the bankruptcy code, and you owe no more than a certain amount of debt, you can do a Chapter 12 bankruptcy, and there is a Chapter 12 trustee. You come up with a payment plan, the creditors approve it, you pay the trustee money, and he pays the creditors. I've never done a Chapter 12. I don't know. We definitely go years without any of those being filed in South Carolina. Chapter 11 is a reorganization, most commonly thought of for corporations and individuals that don't qualify for Chapter 13 would do a Chapter 11. U.S. Air's done several Chapter 11s. Whenever a big corporation files bankruptcy, unless they're just shutting down, they're doing a Chapter 11. It's It's where you have the debtor in possession, where the corporation or the individual is running the show. They have to file all this paperwork with the court. They can't do things kind of in a slack way and try to just say, yeah, I'm in bankruptcy, don't mess with me, and not really follow the rules, because if they don't follow the rules, all the unsecured creditors can get together and form a committee, and they can start trying to tell the judge how they think the business ought to be restructured. And if somebody else doesn't appreciate it, if the U.S. Trustee's office thinks they're not doing things the right way, they can have a trustee appointed, and you've filed a Chapter 11 trying to run your business and reorganize, and all of a sudden there's this trustee looking over your shoulder who's running the show. And so there is some integrity in that system, in that if you don't do things the right way, you'll lose control probably within 90 days or less. And basically, the point of all I really want you to take away from Chapter 11 is it's a reorganization. We basically the debtor has to file what's called a disclosure statement saying how they're going to restructure their debts. The creditors the court has to approve that. You mail a copy of the approved disclosure statement with your plan saying how you're going to redo all your debts to all the creditors, and they're sent ballots, and they have to vote, and you have to get a certain number of votes of each type of creditor to have your plan approved. And there are very complex rules on how to do that. The reason you don't want to do a Chapter 11 if you're not U.S. Air is it's very expensive. I mean, the legal bills for, say, a Chapter 7 that's simple could be as low as $1,000, including all the costs and everything. But if you do a Chapter 11, I mean, you're going to pay most lawyers. I mean, I'm a cheap Chapter 11 lawyer, and I might charge you a $10,000 retainer. The filing fee alone is like $1,039 just to pay the court to file the thing. I mean, there are lawyers in Columbia and Charlotte, depending on the size of the case, they're going to charge you $50,000 to even touch the case. Because once you're in it as the lawyer, you're in the middle of a mess pretty much from day one. And so you have to be, it's usually very creditor driven. You find you're responding to creditors' complaints and motions and things from the beginning if it's a bad Chapter 11. And also one thing, you do have the meeting of creditors in Chapter 11, just like in every bankruptcy, you file your case, you have this meeting of creditors that I talked about earlier. And that's where the U.S. trustee does the hearing and asks you questions. The creditors can show up. You do get more creditors appearing at the meeting of creditors in a Chapter 11 because usually they're more commercial cases. They have more to complain about, or they're more sophisticated in stating their complaints. But it's the same basic function. It's there. It's an information gathering tool. Chapter 13 is a reorganization for individuals. There's a debt cap. If you have more than 300, and I can't remember the specific number because it goes up, but it's about $305,000 in unsecured debt and somewhere around $900,000 plus in secured debt or mortgages or judgments, then if you have more than either one of those numbers, you can't do a Chapter 13. So there are limits on what you can do. But if you do a Chapter 13, basically we file your bankruptcy with a repayment plan saying how we're going to restructure your debt, and you're going to pay a payment to this bankruptcy trustee once a month, every month for 5 years. And when you file your case, you have to mail a copy of the plan to everybody, all the creditors. They have 25 days to object, and then we have a hearing about 30 days later. So everybody's had the plan. If they want to show up in court and ask you a question at the meeting of creditors, they can. And the person that does the hearing at the Chapter 13 is the Chapter 13 trustee. What that person does usually is ask some questions, swear you in, make sure your client's telling the truth about everything, or at least has them say that on record so they can prosecute them if they don't. And they give me a sheet of paper telling me things they want changed about the payment plan or information they want us to get to them that we haven't already gotten to them. And that, they also give a booklet to the debtors telling them where to make their payments, how to make them, and just generally how to deal with their office. And that's generally what happens at that hearing. And then there's another hearing 30 to 45 days later, usually, that's before the judge. And that's where the judge slides into this case, into this process. There's the confirmation hearing. That's where the judge has to confirm or approve the payment plan. And so what happens at that hearing is the trustee has to tell the judge that she approves the plan that you've proposed. And so if there are any changes the trustee wants you to make, obviously you're going to make them, so she's going to tell the judge she wants the plan approved. Because usually in this district, and in most districts, you aren't going to overcome a trustee's objection, because at least in this area, the trustees don't make radical, rash objections. They're not trying to seek glory by making new law. They're pretty reasonable in their requests. But, so the ultimate goal is to get this payment plan approved. And once that happens, you're operating, under the law, and creditors, have to take this money according to this payment plan. They have 4 months to file a claim after you file bankruptcy. The government has 6, because I guess it needs 2 more months. And then when you file a 13, you have to start making your payments to the court 30 days after you file bankruptcy. And you pay payments to the trustee 30 days after you file bankruptcy. And you have to pay your mortgage payment the month after you file. So if I file somebody today, October the 2nd or October 3rd, then your first mortgage payment would be due in your November payment if you have to pay your mortgage on the first of the month, and your first bankruptcy payment is due on November 2nd, because it's 30 days after the day that you file the bankruptcy. And the trustee gives you, Chapter 13 trustee gives you a report every 6 months telling you who's been paid, what's left to pay, and who hasn't filed a claim. And at the end of the case, when it's over, they make sure they've paid everybody like they're supposed to, and then they close your file, and you get an order of discharge. And in a Chapter 13, that means you've paid according to your plan. Now, you think, okay, Chapter 13, I'm paying my creditors. How is this benefiting me? Well, if you're in foreclosure, it's stopping the foreclosure. And what you're doing is you're taking the amount you're behind on the house, which the bank won't take from you because you don't, they either won't take it from you because you don't have it all at one time, and you're spreading it over 5 years. And you're taking your car and you're spreading it over 5 years. And you're taking your credit cards, and if you don't have any equity in your house and you basically are dead bust broke and you don't have much income, you can basically take your car and spread it over 5 years, take the arrearage on the home, spread it over 5 years, and you can pay a penny on the dollar to your unsecured creditors. So it's almost like paying, reducing the unsecured debt to zero and allowing you to keep your house and your car. And so, but if you have $100,000 equity in your house and you owe $80,000 to your unsecured creditors, you're going to be paying $80,000 to your unsecured creditors, maybe plus interest. And you have to cram it into 5 years. So those are the basics of Chapter 13. And chapters, let me see if there's anything in this outline, because it's a really good outline. I definitely recommend reading it. If you, yeah, go ahead.
The 5-year term you use,
That's mandated by law. If there's a way for you to pay less than 5 years, then maybe you can. But the new law said you have to go the 5 years, and there are exceptions. But, pardon me?
not longer.
No, you can't go 5 years long. You can't go longer than 5 years. Sometimes if you have people that walk in with $80,000 in federal tax liability, you might wish you could go longer. That's when you do a Chapter 11, because you might can spread it to, say, 7 in some situations. Any other questions?
Yes, so
Yeah.
if you have a foreclosure
Yeah.
that you're not paying on the house,
Right.
you have a car that you're making payments on,
Right.
you have a charge card with about 50,000 miles worth of debt on it.
Right?
If you file bankruptcy, you don't have to pay the charge card.
Under Chapter 13?
Yeah.
Okay.
And you pay penny on the dollar, whatever is negotiated for the amount that you're behind on the house.
No, you pay the entire amount of arrearage on the house, plus the attorney's fees and costs spread over 5 years. You pay your car loan spread over 5 years with 8.5% interest. You pay pennies on the dollar on your unsecured debt if, and these are the two, I neglected to mention this, the two factors the trustee is looking at when they decide whether they will approve a Chapter 13 plan. Number one, they look to see if you are using all of your disposable income. One of the things we file with the court is your budget, showing what you make, and we back it up with pay stubs for the last 6 months, and your expenses. And they look to make sure those expenses are for necessary items and they're not in unreasonable amounts. And so they basically squeeze every penny out of you that they can in your budget to see what your disposable income is. Your payment to the court has to be that disposable income number. And the second thing they look at is they look at the equity you have in your assets, and you have to pay at least the non-exempt value of your assets to the creditors spread over that 5 years. So even if you can't really afford, a $400 a month payment, if it takes $400 a month to pay the non-exempt equity in your house over, the 5 years, you're going to have to pay it. Does that answer your question?
Well, I was really thinking about the car.
Well, you have to pay when you file Chapter 13, the creditor files a claim saying how much you owe them on that car. And in most cases, you end up having to pay that claim plus 8.5% interest spread over the 5 years.
So you're making the payment on the car.
Oh, you are, yeah. Yeah, you don't get to file, like I said earlier, you don't get to file a bankruptcy and keep any asset with a valid lien on it without paying for that debt.
Okay.
Because I can't tell you how many times I'm asked, oh, you mean I file bankruptcy, I don't have to make my house payments anymore? Well, only if you want to keep it. So, most people keep paying their house payments. Before you can file any bankruptcy in this country now, and this is part of the new law, you have to do credit counseling. And that's it's the two ways you can do it. You can meet with this fellow in Rock Hill who's with the United Way, who's been approved by the U.S. Justice Department to do these debt counseling sessions. He gives you a booklet to read. You fill out this budget form he gives you, and you meet with him for an hour and a half. And then he says, gosh, it looks like you might need to file bankruptcy. And, and then he prints a certificate after you've paid him $45. And I have to have that certificate to file a bankruptcy for somebody. If I don't have that certificate before I file the bankruptcy, that bankruptcy is automatically thrown out. Now, I think the idea is Congress truly believed when it passed the law that people didn't think about their alternatives before they filed bankruptcy, and as far as what their other options were. They hadn't sold their assets, they hadn't cashed in things, they hadn't gotten second mortgages, they hadn't been living without power in some cases. I see that, and they truly believe there's just been this radical abuse in the system. And so they felt like if they made everybody go to credit counseling, if somebody could just tell these stupid people, how to manage their money, they would say, gosh, I don't need to file bankruptcy. Well, in reality, we just have to tell people to go talk to the credit counselor so we can get the certificate so we can file the bankruptcy. Now, so it's kind of a joke, in my opinion. In every seminar I've been to, pretty much everybody believes that. But the thing is, the people that do the credit counseling are good, straight-up folks. They're providing a good service. The other way you can do it is online, and you can get online and sign up with one of these services. They'll do the same analysis. They basically give you a control number at the end. You bring that control number to my office. I'll log on to their website, log in as a registered user, plug in your control number. They charge my credit card $49, and then I can print your certificate, and you pay me $49, which I pay on that charge. And that's how everybody in this country that files bankruptcy, they have to jump through that hoop. Now, a component of that is they said, the one good thing Congress did about that is it said that everybody that files bankruptcy cannot get their discharge until they have done a debt management class. Now, I do like that. I've seen these classes. The only place I know you can get it is this internet website that I use for people, and they only charge like $19. It's a 3-hour thing you watch. It teaches you about budgeting, high-risk loans. It just tells you all the stuff. I mean, I've really, before my daughter gets out of college, I'm going to have her, look at this thing, because it's pretty good. It's a good class, and everybody that files bankruptcy has to watch this before their case will close.
Now, you also tell me you can look at it even though you aren't even remotely thinking about looking at it.
You can't do the debt management part because you have to plug in your bankruptcy case number to have access to it. That's why I haven't figured out.
Of course, you're talking about
The initial thing, the debt, the credit counseling thing, you can do that anytime. They don't charge you until you get that control number plugged in so you can get your certificate. So you can do that anytime. The one I use is hummingbirdcreditcounseling.com. They're out of Raleigh. A couple of lawyers saw the law changing, and they gave up practicing bankruptcy law and opened a credit counseling company. And I know there are a couple of lawyers in Maine did the same thing. That's what they're doing. Now, Chapter 7, basically, you file your bankruptcy. We go to this hearing. 30 days later, the Chapter 7 trustee's got 3 basic jobs. First, he's trying to look at the budget, see if you have any money left. If you have any money left, they probably won't let you do Chapter 7 because you could pay that money and do a 13. If you also have to do this thing called the means test, which they've started with the new law. They take what you've made in the last 6 months and double it, and that is considered they look at that as if it were your annual salary. And you compare that, as far as what you've made in that period of time, to the median family income for a family of your size in, say, York County. And if you make less than the median income, and most of the people I talk to about Chapter 7 do, and your budget shows you're in the hole, then they'll let you do Chapter 7. And then the third thing the trustee does in Chapter 7 is see if you have anything he can sell. And if you don't, it's a no asset case, which means that you don't have anything the trustee can sell. And that's what happens most. I'll go to court with 10 cases, and the usual thing is all of them are no asset cases. I mean, people just, they've sold stuff. They've mortgaged their house to the hilt, and that's so most of the cases are no asset cases. Couple of other things, and then we're about done. When somebody files bankruptcy, earlier I'd mentioned there was the trustee in certain cases. The trustee has certain things called avoiding powers, and one of the things, some of you may have been the unfortunate recipients of a letter from a bankruptcy trustee. If you are paid money by somebody who has filed bankruptcy within 90 days prior to their having filed bankruptcy, and certain other requirements are met, then that person's bankruptcy trustee will be sending you a letter saying, it's my understanding you've received this money, and within 90 days of the time they filed bankruptcy and they were insolvent, and please send that money back. And yes?
Is that similar to what happened in the Home Gold case over here in Pickens, where Lieutenant Governor was involved?
I mean, I'm familiar with that case, but not the specific details. I don't know that the Home Gold case was necessarily about preferences, but I don't know, Mr. Sheedy, do you know anything about Home Gold?
Home Gold was really about investor claims.
It was security issues.
It was about securities issues, and whether those who had purchased securities had been defrauded, and therefore whether they had claims against the bankrupt debtor as well as others who were involved in the issuance of those securities. And what really preference claims, they were more in the nature of just garden variety fraud claims.
Right, thank you. But, if you, the bad thing, this comes up a lot of times in businesses, basically, if you have a small construction company and you're paying all your creditors frantically at the last minute, usually you're paying your buddies and or family members or something like that, and then the company ends up filing bankruptcy. The trustee's appointed. The trustee looks back at the bank records and determines who's been paid within that 90-day period, and if they're family members, they go back a year, or partners or anyone like that, and they can actually recover that money. And a lot of times people ignore that first letter, and then they find out they've been sued in bankruptcy court by the bankruptcy trustee to get that money back in. The purpose is to get all the money back that the debtor had within that time frame and give everybody a little teeny piece of it, and that's the concept of trying to be fair to everybody. And that's what the preference concept's about. The other type of avoiding power would be dealing with fraudulent transfers. If you have transferred your house to your sister because things aren't looking very good for you financially, then basically your bankruptcy trustee can get the house back if your sister didn't pay you the fair market value of what was transferred. That's not an uncommon thing, but if the person who filed the bankruptcy was honest with their lawyer and their lawyer asked the right questions and checked the right records, that transfer would have been uncovered before that bankruptcy was ever filed.
What's the length of time that you would have with the transfer? Say you transferred it 2 years ago.
Right.
But you knew in your heart you were going to be doing that 2 years down the road.
Right.
What's the length of time that they
Well,
would
there are two kinds of fraudulent conveyance statutes that are mainly used. One of them is the bankruptcy fraudulent conveyance statute, and that's Section 548 of the Bankruptcy Code. And it used to be 1 year. Any transfer made within 1 year was deemed fraudulent. The new bankruptcy law extended that to 2 years. And under state law, somebody not in bankruptcy is subject to the same type risk as the Statute of Elizabeth. And the statute of limitations for someone trying to undo that transaction used to be 6 years. Now I believe it's 3. But what comes up in the bankruptcy context usually is the statute of limitations doesn't start running until the date of discovery, and most people are going to argue, well, we didn't know about it till you told us, and so it's not, it's not easy to get around that statute or to be able to claim the statute of limitations. And when you file your bankruptcy, the paperwork asks what transfers you've made in the last year. And when you go to your meeting of creditors, it is very rare that the trustee doesn't ask, what transfers have you made to anybody in the last 10 years of any land? I mean, they always ask that because they frequently get the answer they want to hear, and they go after it.
One question, please.
Yeah.
If someone is judged to be bankrupt by the bankruptcy court, actually what are the consequences for the person that has been judged bankrupt?
Well, when you file the bankruptcy, you're in bankruptcy automatically. And then, so you have sort of put yourself in that situation. There are times when your creditors can put you in bankruptcy. That's called an involuntary bankruptcy. That's pretty rare, but it happens. I've done one of those before. And the debtor who is put in involuntary bankruptcy has the right to have a hearing and prove that he's not insolvent and that he shouldn't be in bankruptcy. But in most situations, the debtor has chosen to be called a bankrupt and is seeking to get the discharge or the wiping out of all of their debts at the end. And, not all the debts are discharged, but some debts like recent taxes, school loans, child support, alimony can't be discharged, and there's a statute that sort of has a laundry list of those in the bankruptcy code. But the consequences, you get a court order that wipes out your debts or whatever wasn't paid under your bankruptcy plan, which was approved by the court. And are you talking about the practical consequences?
Yes.
Okay. Just from what I've seen from doing this for 20 years, I don't know. I mean, there are consequences. I'm assuming you're going to be turned down for loans from some places, maybe, all the places. I'm assuming you're going to have to pay a higher interest rate, at least on your first loans you might get on a new car, house, or whatever. But for the most part, I think that, I have, people I've actually represented more than once, and people I've been in Harris Teeter and had 5 of my clients walking around. So, I interact with people I've represented in the past and find out how things are going. And, most people can get houses and cars and things they need. A Chapter 7 and Chapter 13 are both on your credit for any bankruptcy is on your credit for 10 years. But I don't know that it really ruins your life. You have to look at what the people's situation is when they choose to file. And they usually,
Can you accrue assets?
Oh, yeah. If you have filed the bankruptcy and you've done it properly and you have disclosed everything you have and you haven't done anything wrong and your case goes through, you're entitled to basically acquire anything. The whole purpose is a fresh start, to start over and be able to acquire things and, be able to say, well, I got divorced, my business failed, things were bad, but since that day, after I got rid of everything and started over, I'm able to do things like I'm able to. I think my time is up. I don't want to encroach on Mr. Sheedy's time. Does anybody have any?
One question. Is there a limit to how many times you have to wait a certain amount of time?
When you file a Chapter 7, you can't file another one for 8 years. It used to be 7 forever, but they changed it to 8 years with the new law. When you file, and so technically every 8 years you can file a bankruptcy. But it's not something, most of the people that end up filing a bankruptcy, they don't want to do it again. It's usually something dramatic that forces them into my office 2 times. But a Chapter 13, they're basically, if you file your case and you finish it, you can't get your debts discharged if you file another one within 4 years after your case was discharged the last time. And that's a new twist. Before, you could file as many Chapter 13s as the court would allow you to do. And around here, that's 2, maybe 3 if you were pushing it. Now, there's that provision I was talking about earlier, that if you file your Chapter 13 and it's dismissed within a year and you only have 30 days of the stay without getting the court to extend it. And it's pretty rigorous. I've tried to do that in a few cases since the laws changed, and I've lost more than I've won. They pretty much look at the budgets and the changes. They want to make sure you really are going to make it that next time.
Could you
Okay?
explain the term coming out of bankruptcy, Chapter 11, as with U.S. Air?
Well, it just means that their bankruptcy, that they have started doing what they are supposed to do under their plan of reorganization. And the court, when you file a Chapter 11, you file you request for a final decree. You file a request for a final decree, and you report to the court some final financial statements, and you say that you file a report of substantial consummation, saying that you've basically started on the path to this reorganization process you said you were going to do in your plan. The judge signs off on the order of final decree, and for the most part, you're out of bankruptcy and back into this new zone. Okay?
A number of times.
All right.
Yeah.
Thank you.